Hey, how's it going? It's Brandon with Myers Realty again here. I'm a real estate agent here in Delaware, and again, I'm super excited to bring this to you. I got Adam here with me again to talk about estate planning and wills. I mean, I know it can be a pretty uncomfortable conversation to have, but it's something very important that I think a lot of people kind of put off and think they have time to do. And today I'm just here with Adam, who's going to tell us a little bit about the process and answer some questions that we have.
Yeah, thanks for having me.
Yeah.
Just again to reiterate, I'm Adam Gerber. I'm a partner here at Wolfe Associates. We're a real estate firm, a real estate and estate planning firm. So I'm here to answer some questions about estate planning.
And that's in Delaware and
Maryland.
Maryland. Yep. Okay.
Yep.
So yeah, if you're not in Delaware and you're in Maryland, still reach out to them. You reach out to me as well. I know I have people who can help you. Pretty much anywhere.
Yep.
So I guess could you give us just a quick overview of exactly what goes into I guess estate planning just in general?
Yeah. And I have found that some people are a little confused by what I mean when I say estate planning. And I think the conception is that, I don't have a big estate. I don't own, millions of dollars in assets, so I don't really need an estate plan. But that's not really what I'm talking about.
Sure.
What I mean by estate planning is really just three basic main documents, and then maybe another one called a trust, which we'll talk about. But first of all, I would say you'd probably be surprised when you start looking at all your assets, what you really have. So you have, at least most of us will have some assets that
Sure.
we need to address how those assets would be distributed after our deaths.
Mhm.
And then especially if you have young children, minor children, you really should have a will and then a power of attorney healthcare directive, but especially the will to provide for who would take care of your kids and who would manage assets or money for your kids after your death. So very important to have these main documents. And that's really what I mean by estate planning. It doesn't have to be a multi-million-dollar estate. If you have a house and a car, even not those, but kids,
Yeah.
we should talk about the estate planning documents.
So I mean, the wills and the estates are kind of just like more so of a playbook for your family after you're gone.
Yeah, exactly. And that's how I think of it and describe it. It's really something you're doing to help your family if something were to happen to you by putting a good plan in place, putting it in writing, making it enforceable. In other words, it really takes the burden off your family to know what you wanted and then to help carry out your wishes.
Okay.
Yep.
So I mean, I know it can get pretty complicated, when you start diving into other assets and everything such as that. So what documents do you recommend someone bring if I'm just like, hey, I want to create a will so I have something in place?
Sure. Well, actually, we generally use a questionnaire or an information sheet we'll send out to the client beforehand. And it's a few pages long, but it's a good exercise for them and helps give me the information I need to give them, the best advice I can.
Sure.
So that document asks them to list personal information, their names, kids' names, things like that, but also to go through and really go through the exercise of just listing all their assets. So, like I said, most people are surprised when they really start listing out all the things they own, what they do have and
Yeah.
what needs to be addressed if something were to happen to them. So that helps them organize their thoughts and put everything together in one place, and then helps me to look at what they have and to make some specific recommendations about various types of assets or any family considerations, family dynamics that
Sure.
might be going on. So I have clients bring that, and if they have any existing estate planning documents, such as a will or trust or power of attorney or healthcare directive, I have them bring those too,
Sure.
just so that I can look at those and let them know if I see any changes that need to be made.
Yeah. So I guess that pulls me right into the other question that I have. I mean, usually when we make our will, we're not going to want to make it at the end of our life. Usually we make it when we're a lot younger.
Sure.
How often do you recommend, like, I guess a will checkup, if you
Yeah,
will?
sure.
How often do you recommend that happen?
Well, so I'll draft the will to try to accommodate most scenarios that would come up, so you wouldn't absolutely have to change it. But, you can't account for every scenario. So
Yeah.
I recommend revisiting the will every, let's say, 3 to 5 years. Doesn't have to be necessarily every year, but um, so every 3 to 5 years, unless there's some major life change that happens in the meantime. So if there's a birth or a death or a wedding, or you family dynamics have changed and you want to change something in the will, then
Sure.
definitely want to come back to me. But it is relatively straightforward to change a will. You can make an amendment to it, which we usually call a codicil, or you
Sure.
can restate the whole will and do a new one if you need. But back to your question, I would say every 3 years or so, or if there's any change in your life that makes you want to kind of reevaluate the estate plan.
Yeah, so if I made it before I had kids, I have kids now, I probably won't update it.
Yes,
If I bought,
very
you know,
important to do that.
yeah,
Yeah, yeah, yeah.
especially in real estate, I mean, especially like when we're talking about a real estate, I mean, if I buy more assets or I get rid of
Mm-hmm.
assets, rentals, stuff like that, like
Yes.
anytime anything like that happens,
Mm-hmm.
or any big life changes, like
Yep.
God
And
forbid,
that's a good point that in your realm too. If somebody starts buying some assets like real estate things, we really do want to reevaluate the plan. Talk about LLCs, maybe trust planning. So yeah, anything like that,
Sure.
I would count that as a major life change too when you start buying some
Yeah.
rental properties. Yeah.
So yeah, I mean, of course, I mean, it's always a big thing. It's one of the
Yeah.
biggest purchases you'll ever make, more than likely.
Yeah.
And
Exactly.
so
Exactly.
definitely want to check up on that. So yeah, it makes a lot of sense. I guess more so, like you said in when we first started talking, if I'm a, young 18, 19-year-old and I don't have anyone dependent on me, I don't have kids, I
Yeah.
don't have anything, and I don't have much to my name, I mean, does it make sense to still have a will?
I mean, I would still recommend it. It can
Sure.
be pretty straightforward, not too expensive. Just set up a basic will. Even if you don't have kids yet or much assets, you still, let's say your parents are alive, and if you happen to die before them, you really want to plan in place so they know what you wanted, and
Sure.
then you can specifically authorize them to be the ones to handle your estate.
Okay.
I had that happen relatively recently. Someone who was pretty young and did not have kids or a spouse yet, but he died, and he had fortunately drafted a will and gave his parents the authority to do what they needed
Sure.
to do. So yeah, I think it's important to have a will, even if you're young and don't really have a lot in assets, because you know, no time like the present. You may
Yeah,
as well
definitely.
draft it now. You will eventually probably you'll get married, have kids, get a house, get other assets, and you
Sure.
may as well have those addressed in the will to the extent you can. Now, I will say that there are certain laws in Delaware. If someone dies without a will,
Sure.
there are laws that serve kind of as a default and will govern who can manage the assets of the estate and be appointed as the executor or personal representative in that case. Those laws are called the intestacy laws, meaning that the person did not have a last will and testament. That's kind of where the word
Yeah.
comes from. Uh, but those are just kind of default laws saying that, well, your next of kin, let's say your parents or if they're not alive, your siblings, they would be the ones who could ask to be appointed as the personal representative,
Sure.
and that your assets would go to basically your next of kin in equal shares.
Okay.
And in many cases, that's fine, but you may want something different. So if you want something different than that, you really need to put your wishes in a will to make
Yeah.
sure they're carried out.
Yeah, definitely. I mean, like I said, I don't know who said it, but they said if you want, if you don't really like your family, don't have a will.
Yeah, right.
So
I mean, yeah, that's funny, but it really is true. I see it all too often because I do some estate litigation as well. And when somebody does not have a good plan in place, that opens up the possibility of misunderstandings and disagreement and arguments, which then can lead to litigation. So yeah,
yeah,
you are really doing your family a huge service by putting your wishes in writing. Now, kind of going back to your point about, let's say, the 18-year-old who
sure.
doesn't have much, as part of the estate planning documents, I recommend three main documents at least, and that is a will, like we've talked about, but also very important are a healthcare directive and a power of attorney.
Okay.
The reason I recommend those is because, let's say that 18-year-old got in an accident, something happened to them, and they became incapacitated, like in a coma or just otherwise
Sure.
incapacitated.
Yeah.
They need to have a document in place that gives legal authority to someone of their choosing to serve as their agent to make financial decisions and medical decisions on their behalf.
Yeah.
Because technically, nobody has that legal authority. Sometimes maybe a parent can step in, but you'd be surprised. I mean, really, no one has that legal authority. And if you don't have the power of attorney and healthcare directive in place, then your family, somebody will have to go to court and get guardianship over you, and that's a
Yeah.
very time-consuming, expensive process. And there's a lot of court oversight for good reason, but there's a
Yeah.
lot of court oversight on that. It's very difficult to actually follow that, all the guardianship rules. So you're
Yeah.
saving your family the time and the money of having to go to court to get guardianship if you just have a power of attorney. And that's the document that names an agent to make financial decisions for you if you can, and then a healthcare directive, which names an agent also to make medical decisions for you,
Sure.
but then also has some end of life
Yeah.
decisions in there. So you can make those decisions in advance so your family doesn't have to.
Yeah. So like if they want you to pull the plug or not.
Yeah, 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 that's
Yeah.
the
Yeah.
classic one.
Yeah.
That's right. But
Yeah.
but what you're doing there is you are putting in place your wishes and making them enforceable, but putting them in writing.
Right.
That way your family doesn't have to guess at what you might have wanted or wonder about what you wanted. It
Yeah.
really takes that burden off of them.
Yeah.
I talked to families all the time who are so appreciative that their loved one had a healthcare directive.
So, I mean, talking about expenses and how expensive it can get without the
Sure.
will, I mean, what is, I guess, what would be a typical price point for something simple? Of course, we know everyone is a little bit different. If you got $2 million worth of assets, obviously it's not going to cost you $200 to do it.
Yeah, sure.
So, I guess my two questions would be one is, can you do a will on your own?
Hmm.
And then number two, if you do use an attorney, someone who specializes, I don't know why you wouldn't want to, but
Sure.
if you did go that route, is it pretty expensive, or what
Yeah,
exactly, what kind of
there,
cost you'd be looking at?
sure, good question. There's a bit of an investment here. And to answer your first question, yes, you can draft a will on your own. You got to watch out, make sure you're following the proper formalities as required by Delaware law to have
Sure.
it, witnessed and properly executed and all that. And my greater concern there is that you just may not know what you don't know. So you're trying to fill this out, and there may be some provisions that seem pretty straightforward and aren't. So yes, I would always recommend using an attorney.
Sure.
Now, if you do decide to use an attorney, the price will vary depending on exactly where you go, of course, but really more so depending on which documents you decide to implement in your estate plan.
Yeah.
So if you're going to do the basics like a will, power of attorney, healthcare directive, I think you can plan to pay around $1,000 or so, maybe a little more, maybe a little less. And then if you start talking about trust planning, which is vital to help avoid the probate process, which we've talked about in another one of these episodes, then you're talking more around $1,500 to $2,000, depending. And of course, it just all depends how complex your plan is, whether you want to factor in, whether you have business assets and other things that you want to factor in. But I'd say that's a general range, for what you're going to spend, at the time we're talking now.
Yeah, I mean, and like I said, I mean, it doesn't seem outrageous for peace of mind. I mean, yeah.
It's actually really huge for your family. And the more I do this, the more I realize how important it is to do this for your family.
Sure.
Because for example, if they have to go through the probate process, generally they're going to spend at least that amount of money, if not more, just on attorney fees to help go through probate.
Yeah.
So you're saving your family more money, after your death by making a good investment now, setting up a plan, gives you peace of mind, but really takes the burden off them.
Yeah. So I guess we can get into, I guess it's a little bit more advanced, or for someone who's maybe investing or something like that. So
Yeah.
what's the main difference between just a regular will versus a trust?
Yeah, sure. So the will states who's in charge of your estate, and your estate, as I'm using that term, means whatever assets you own at your time of death in your sole name. So what the will governs who's in charge of those assets and how those assets are distributed after your death.
Yeah.
Now, if you have just a will, those assets have to go through the probate process, meaning that you file the will and death certificate and a bunch of other paperwork to open up the estate with the Register of Wills office.
Yeah, as we went. Yeah.
Yeah, and we've gone over that in
Yeah.
another episode.
Yeah.
I won't go into all that
Yeah.
again. But there's a whole probate process that you have to follow if you have a will. And so the Register of Wills office is just kind of overseeing that process.
Yeah.
That process, as I mentioned in the other episode, takes about 9 months to a year usually, and there are a bunch of fees associated with it. If you set up a trust, then you can actually keep assets in the trust out of probate. So a trust is a separate document that I would draft up. It's basically an agreement between the grantor or the trust, or the person who creates the trust, and then the trustee, the person who is managing the trust. So in most of my estate plans, I work with clients and have them set up a trust, either individual or joint, maybe with their spouse.
Sure.
They're the ones creating the trust, but they retain the right to be the trustee, the one managing all the assets. So they're still fully in charge of all those assets. And what they do is they transfer assets into the trust, and there are various ways to do that. For example, with real estate, you deed the property into the trust, or you change the name of a bank account to put it in the trust. But if you put those assets in the trust, those assets do not have to go through probate, so you avoid all that time and expense of probate by keeping assets in the trust.
And that would probably help with, tax liabilities as well, right?
It can, yeah. Trust, usually a different kind of trust, called an irrevocable trust, but it can be used for estate tax planning as well. Yeah, and even in some contexts, long-term care planning. But those are two totally separate conversations. Yeah, but you're right. So trust, trust in many of the ways, or in many ways, is similar to a will in that it dictates who gets what assets after your death. But also, it's important to have that because the assets in the trust don't have to go through probate, and the trust also addresses who manages assets during any period where you were incapacitated, like
Yeah.
if you were in an accident, became incapacitated, your trustee would automatically have control over the asset. Your successor trustee, I should say, has control of the assets in your trust.
Okay. So, I mean, just a general, like, I guess dumbing it down a little bit would just be more so with the trust, you don't have to go through that probate process.
Exactly.
And more than likely, I mean, correct me if I'm wrong, but those are, it's more so of a confidential, not public record type thing.
Yeah,
with
exactly.
The assets that
Yeah, and
the
that's a
trust
good
holds.
point. An added benefit of a
Yeah.
trust is that while the will is filed with the Register of Wills office and made public record, the trust is not.
Yeah.
Yep.
Okay. And I mean, I guess one last question I would have for you: is there anything specific that you think that should be, I guess, addressed while doing a will, or some common mistakes or common things that you see that maybe people trying to do it all themselves, or doing and
Yeah, sure.
potentially shooting themselves in the foot?
Sure. I mean, yeah, again, you just don't know what you don't know if you do it on your own. There are certain terms of art that are used, like per stirpes and per capita, that can be used. You might have heard the term and kind of think you know what that means, but you got to be very careful about how you use certain terms because they have legal significance, specifically in that context, as to who inherits what and who would inherit. For example, if a child predeceased you, you just have to be careful to make sure that you are accurately representing your wishes. For example, if a child dies before you, so let's say you have 3 children and one of your children, predeceases you, well, who would you want to inherit their 1/3 share? Let's say you're going to divide equally. Do you want their children to inherit that 1/3 equally to them, or do you want it to go back to the other siblings? How would you want that to happen?
Yeah.
So there are just a lot of things that you don't necessarily automatically think about.
Yeah.
And that's why it's just beneficial to talk to somebody who does this all the time
Yeah.
and can help walk you through those various decisions that you may not even know you need to make.
Yeah, I mean that just sounds like the movie Inception when you're talking about a child inside a child inside another child.
Yeah.
It's just
No,
crazy.
exactly. I know,
Yeah.
and it seems like it all's pretty straightforward, and you're just signing some papers. But
Yeah.
these are weighty decisions. Big decisions, like even in the healthcare directive, end of life decision. These are big decisions, and it's worth taking the time to really think through and talk them through with a trusted advisor to just figure out exactly what choices there are to be made and to make sure you're making the right ones for you and your family.
Yeah. So I mean, I guess all in all, I mean, from if you get anything out of this video, is more so the whole will is more for your family, and I know it's a difficult conversation to have, a different thing to face, your mortality and other things like that, but it's definitely something that should be done, and again, should be done probably professionally to make sure you're not shooting yourself in the foot. And if you have any questions, like I said, Adam's here, to help you out with anything you need. We'll have his contact information somewhere. Mine, if you have any questions, regarding real estate. But yeah, I just want to thank you again for your time and
Yeah.
going over this, because I think it's a conversation that needs to be had, that some people just think they have time to have, but the saying is, life comes at you fast. And so, 1 year turns into 10 years down the road, and you're in a totally different situation or predicament, and you just don't want to get to the point to where as though they need this and they don't have it.
Yeah, absolutely. Well, I appreciate you having me to answer some questions. And yeah, this is an easy conversation to put off, or put off thinking about it, but
Yeah.
it's so important to address this now. And communication is key. You want to talk about it with me and with your family, especially. To make sure they know what your wishes are and that they're assured that you have a good plan in place to help them if something were to happen to you.
Yeah, definitely.
So, all right. Yeah, appreciate it.
I hope you got some value from the video, and if you got any questions or anything, feel free to reach out to Adam here at Wolfe Associates, or like I said, you have any real estate related questions in Delaware, feel free to hit me up.